Hi everyone, it's so great to be back on the show, despite what's going on outside, and unfortunately I'm not just talking about the weather. I'm Vicky Gilwell from Privacy Culture. I'm joined by my business partner Steve Wright.
Hello, it's so lovely to be back. We've missed you all. I'm just really excited. Sorry, I can't contain my excitement, Vic.
No problem at all, Steve. No problem at all. It's Friday as well. We have some special guests today to help us unpack the Schrems II decision. We have Antonis Patrikios. Antonis is Denton's EU data privacy and cybersecurity specialist. Welcome.
It's my pleasure to be here. Thank you, Vicky.
Thank you so much. And we also have Brian O'Connor with us. So Brian is Head of Data Privacy and Business Protection at Aviva Ireland. Hi, Brian.
Hi, Vicky. Very pleased to be here.
Fantastic. So, in a meeting of the European Parliament's Committee on Civil Liberties, Justice and Home Affairs in early September, Commissioner for Justice Didier Reynders expressed hope that the long-awaited revision of the Standard Contractual Clauses, better known as SCCs, will be finalised by the end of this year. And this statement undoubtedly caught the attention of us in the privacy community, and many of us privacy professionals, and you of course, are under intense pressure from their organisations to continue with the transfer of EU personal data to countries outside of it. At the same time, of course, they need to comply with a series of additional measures imposed by the Court of Justice of the European Union in the Schrems II decision. And of course, this creates so much pressure and uncertainty for all of us. And amid this, we're all looking for any guidance and certainty that regulators can provide. The revised Standard Contractual Clauses are seen as part of the solution, although we hasten to add it's unlikely they alone will address all of the requirements imposed by that Schrems II decision. So Antonis, I'm actually going to start with you. Can you just give us that piece of background? What was the chronology that led up to that Schrems II case, please?
So our story begins in 2013 when an individual, Mr. Mark Schrems, filed a complaint with the Irish data protection regulator requesting that a US social network that was transferring his data to the United States should be prohibited from doing so on the grounds that the law and practice in the United States did not ensure an adequate level of protection given mass US surveillance of data and access of public authorities to the data. The matter was referred to the Irish courts, which then referred the matter to the Court of Justice of the European Union on a point of law. At the end of this process in 2016, the Court of Justice of the European Union invalidated the EU-US safe harbour, the predecessor of the Privacy Shield, and then referred the court back to the Irish courts and the Irish regulators. And then the same process took place again, with one significant difference, that at that stage, the said US social network was actually relying on the Standard Contractual Clauses. And Mr. Schrems were encouraged by the Irish Data Protection Commissioner to adapt his complaint, which he did, and the same process took place again. The Irish regulator referred the matter to the Irish courts, which referred the matter to the Court of Justice of the European Union, this time the question being whether the transfers to the United States on the basis of contractual clauses, the standard contractual clauses, was lawful. And as we all know, the court decided that yes, exports of data from the EU on the basis of standard contractual clauses are lawful on the basis that the standard contractual clauses themselves required the parties to them to ensure that they can comply with them, and if required, implement additional safeguards. And incidentally, the Court of Justice of the European Union took the opportunity to throw the EU-US Privacy Shield under the bus. So where we are right now, EU contractual clauses valid, but clear expectations for assessments and additional safeguards, US Privacy Shield invalid.
Perfect, Antonis. Really, really succinctly put. And you spoke a lot about standard contractual clauses there, which of course, you know, are a key method of transferring data. But Brian, it isn't the only method, is it? There are other protection methods that can be used.
Absolutely, Vicky. Obviously, standard contractual clauses are the most common method, and I think some of the surveys that have been used have referenced as much as 80% of transfers covered by them. But Articles 46 and 49 of GDPR do allow for some alternative methods, the most common of which is probably binding corporate rules, which in itself has some limitations because obviously they're very expensive, very difficult, very long entry to put them in place, but they also only cover data transfers within your organization, which wouldn't always help. And they are in and of themselves now affected by this judgment, because even if you're relying on BCRs, you still will have to carry out an assessment, given that any process that's used under GDPR for transfers has to take account of your data having appropriate safeguards, having enforceable data subject rights in the jurisdiction that you're sending to, and an effective legal remedy for subjects who feel that their data subject rights have been infringed. And all of that means that, unfortunately, if you are relying on an alternative method like BCRs, you will have to carry out the same kind of assessments as you might for standard contractual clauses. There are some other less common, and particularly under Article 49, you can use consent, but you have to be really careful with consent, as we all know, that it's explicit, that everyone knows exactly what's going on and that it's not forced in any way. And you could, in some cases, use your need to conduct a contract. Again, those type of transfers for contracts or for a legal case, any of those are not expected to be ongoing. They're more appropriate to individual cases, as are any of the specific commitments that may be in place between regulators. So the options are there, but they're not very palatable. And really, people come back to standard contractual clauses in most instances as the most effective way to manage transfers, Vicky.
Thanks, Brian. I think that was really helpful. And of course, you know, I'm not sure if everyone is aware that there are actually two sets of standard contractual clauses as well. One that deals with international transfers of EU personal data to processors, and the other one to controllers. So it was clear in the court ruling, in the decision, that supplementary measures were also required in order to protect these data transfers. But also, the CJEU made it very clear that in issuing SCCs, the European Commission has no obligation to evaluate the level of data protection of the countries to which EU personal data could be transferred under them, and that's paragraph 130 of the Schrems II decision, in fact. What do you think we can hope to see in this space? I'm going to put this to you first, actually, Steve. You know, what are you actually seeing happen in your own client environments? And then I'll ask Antonis and Brian to talk about their own experience as well.
Yeah, thanks, Vic, and thanks, Antonis and Brian. Really good explanations. I think what we're seeing, certainly for our clients, is a level of activity about understanding what those recipient countries, you know, what laws are in those recipient countries that may act as appropriate or adequate. And that in itself is can be quite time consuming. So certainly on the cases and the clients that we're supporting, we're now doing that on a risk-based analysis, or, you know, i.e. what's the type of data that's being traversed or transported or accessed via some of those countries, what's the environment or the regime in those recipient countries, and how receptive will they be if it gets to the legal remedies. and then we're sort of doing an evaluation based on what you would typically see in a sort of privacy impact assessment, you know, sort of red, amber, green type assessment. So what we're doing is we're advising our clients around sort of not if you like the legal position, because we can't do that, so we're not a law firm, but what we can do is we can say we've looked at what the types of data that you're handling, what's being transferred overseas to where, what's the regime in those different countries, the legal and regulatory regimes, because there are other things you have to take into consideration. There's cybersecurity laws, there's data retention laws, and all those kind of good things, or repatriation laws that need to be considered. And we're helping them by facilitating that risk assessment process. So that's as much as we can do in terms of the advice given. We can't do that. We work with Dentons and other law firms, you know, to help give that sort of legal advice, or if there's a redefinition of those standard contractual terms. The only thing I would add, though, is in doing so, because a lot of organisations went through this exercise in readiness for GDPR, what I have found in our experience is that there was a reliance, almost an over-reliance on those contractual clauses, and the level of due diligence, I would say, wasn't particularly, high. As an observation, I would just say, generally speaking, I found that there was a lot of yes, do we have model clauses? Yes, tick. Okay, move along, get to the next one. And I think that's that's understandable, because there was a big pressure, there was a big run up to GDPR. Everyone was, well, people like us, practitioners were rare as rocking horse doo-doo. So there was a big pressure on everyone to get the job done. And I think what's happened with Schrems is it's now giving us all a new, fresh impetus to actually do the job properly, if I dare say.
Yeah, I think it's a really good point, Steve. I think, just in the cybersecurity world, and Antonis, you probably witnessed this as well, there's always, I think, been an over-reliance on third-party contractual obligations, for example, and SCCs are no different, really. Somebody said to me the other day that they think there's probably a drawer somewhere just full of these dusty old things that people have just sort of signed and then forgotten about. And of course now they're in sharp focus, or certainly they need to be. So Antonis, is this approach, this kind of transfer impact approach, something that you've seen as an assessment approach with your clients, or something that you're advising clients to do?
Yes, that's absolutely right. We're seeing quite a lot of that, and I can explain some of the variations, but just to touch very briefly on a couple of the key points that Steve made. So, number one, the factual assessment of your data export is absolutely essential, and I'm glad to hear, Steve, that you're doing a lot of work in this area. And in many respects, what the facts will establish will determine the legal assessment that's going to follow. Put it in its simplest form, not all types of personal data and not all types of data exports are of interest to the law enforcement authorities of the destination country. So that's point number one. And point number two, again, very validly made by Steve, one of the good things, in my opinion, that the Schrems judgment has achieved or will achieve is that it underscores very clearly that data protection is not about papers and contracts and ticking boxes. It's about understanding what you're doing and generally assessing what you're doing and taking appropriate steps. So to answer the direct question, Vicky, yes, these assessments are required. There is no doubt about that. And yes, we are seeing clients doing them. It is perhaps a bit surprising that we're not seeing as many clients as we thought we would see actually taking the effort to carry out detailed assessments of the legal regime of countries like, and one could argue the United States is fairly straightforward, but it's not that straightforward if you're trying to assess the law enforcement access regime of China or Russia, just to mention a couple of examples. But we are seeing clients, and these tend to be the biggest, sort of most sophisticated corporations or financial service institutions that have budget and resources. They start assessing the key destinations. We are hearing from other clients that they're doing this work in-house, sometimes linking with similar requirements in other compliance areas. We are certainly seeing pretty much all of our clients actively thinking about this at different levels, trying to consider their options, trying to assess what are the potential additional safeguards that they will need to put in place. And then finally, I personally see a lot of clients whose response to this tends to be driven by customer pressures. So if you think about service providers, data processors, who are data importers, you can see how many clients are reactive and are just responding to what the customers are asking to confirm as part of them carrying out these assessments. And we've seen very interesting questionnaires flying around, whether it is the one, the none of your business questionnaire that Mr. Mark Schrems very helpfully put out the day after the judgment. I'm being sarcastic here, but also we've seen some very interesting German variations of such questionnaires.
Oh, thanks, Antonis. That's great. I'm glad you brought up, the wider piece, really. And there's an ethical question as well that I think a lot of organisations are really starting to ask themselves now about this. And you also mentioned earlier on, and I want to bring this one back to Brian as well, that you're surprised that not all organisations are actually looking more widely, not just at the impact of the data that they're transferring, but generally, at the impact of privacy, the privacy risk within their organisation. And Brian, we are in the middle of a pandemic. Surely that must have some bearing on where the focus lies in an organisation now.
Well, yes and no, I'd say, Vicky. I mean, yes, we're in the middle of a pandemic. I think that doesn't absolve any of us, obviously, of our obligations under privacy. And I think it would be a mistake for people to decide that because there's a pandemic, there are aspects of this that they don't need to assess as quickly or as widely as perhaps they would in other circumstances. It's interesting. I would completely agree with the previous two speakers. It's always great to be the third question. But in particular, when Antonis said this previous reliance on contracts, it's probably a personal bugbear of mine. Of course, I am here in my personal capacity today rather than speaking on behalf of my company, but I think it's probably the same thing given that I implement. But I believe what I've seen, not just across the whole of industries and debates in the privacy world, a very heavy reliance on paper. And GDPR requires us not just to have a contract in place, not just to understand what data we're transferring, but to be able to evidence how we are overseeing that the data processors that we employ are implementing GDPR or equivalence. And that piece of equivalence that the judgment refers to, I think, is important as well in trying to come to a conclusion on the assessment and what should be in it and what shouldn't. It's really, the principles of GDPR and can they be properly reflected in the destination that we're sending data to. And I would be just a little concerned at the emphasis on the assessment piece, that in turn becomes a piece of paper. I've done the assessment, I've ticked all the boxes, therefore that's enough. My suspicion of the way that this will evolve is that we will get challenges, not just from Mr. Schrems and his cohorts, but from regulators. And they won't just be looking for paper. They'll be looking for, yes, now that you have done the assessment and you do understand what you're doing, have you taken all the steps around minimization, around pseudonymization? Are you constantly going back and assessing, are you doing reviews of what your people in other jurisdictions are doing? And that, to me, operationally is the really big challenge. We can all employ, you know, Antonis and all of his cohorts and pay them small amounts of money, of course, but end up with filing cabinets or virtual filing cabinets full of documents. That's not going to be enough anymore, guys.
Yeah.
Yes.
Can I just add?
Steve, of course.
Yeah, sorry. I really love what you were saying there, Brian. That was absolutely spot on. I think this goes absolutely to the wider point of accountability. You know, and we as professionals, you know, we are all trying to drive through you know, not only the principles of privacy and what that means to individuals and to our organizations that we look after or represent, but actually what we're trying to do when it comes down to it is, as Brian was touching on, who is accountable, who feels like they have the responsibility and can actually come up with a cohesive evidence-based story as to what they're doing and where the data is going and what are the mechanisms of control, such as encryption or pseudonymization or normalization, as Brian mentioned. And I think to me this gets to the heart of the matter, which is how can we as an industry continue. And I think Antonis made a good point, because what he was saying was, you know, maybe slightly tongue-in-cheek, but he's surprised that more organizations, professional large organizations with, you know, huge amounts of data transfers going on, aren't all sort of literally running for the hills to make sure that they do this. And I still think it goes back to this fundamental piece where we are, if you like, on the journey of, we're still nascent, you know, as an industry, as a concept about privacy being, you know, part of our DNA, part of our rights. And I think that's comes through in the attitudes of those CEOs, CFOs, even GCs, dare I say, that they don't, it's still not there yet, is what I'm trying to say. There's still not a collective consciousness of privacy in these large organizations, and I think we'll get there, which gives me great hope. But I think we're still quite nascent in this journey, and I think we've got some way to go. And that's kind of one of the reasons why I think these enforcement actions that we see, these lone, you know, rangers such as Mr. Schrems, you know, we're sort of like admiring them, because what they're doing is they're bringing back to business, back to home, the importance of data and our privacy rights. And I think that's what's so good about the Schrems case and any of those cases that continue to highlight this big issue. And we're going to see more litigation. We're already seeing it with the Marriotts and the others. And you know, that's a whole different debate for another day. But you know, the important thing here is about accountability.
That's a really great point, Steve. You know, we can all get caught up in deciding what supplementary measures to use when transferring data, but actually when it comes down to it, it is all about individuals and their rights. Now, we do have quite a lot of questions in the question box, so I'm going to start asking some of these, because I do want to make sure we get through them all if possible. So first of all, can Microsoft be used as a processor when using their data centers in the EU or the EEA? And do they provide enough assurance in their standard agreements regarding transfers to the US or any other third country? I'm thinking about Azure. Does anybody want to try taking that one, or consider taking that one as a starting point?
I'm happy to have a go. I won't comment on the validity of Microsoft's terms or anything specific, but I'll address the question at a very high level. The idea that somehow we should stop using service providers of that caliber just doesn't make any sense. It's impossible. You can't run a business this day and age if you do this. That's your starting point. Second, you look at some of these companies, and generally the level of effort they're putting into privacy, the level of thinking they're putting into ensuring that the customer data is protected, A, in a legal paperwork sense, if that was what the question was aimed at, B, in a genuine privacy and accountability sense, and C, perhaps more importantly than all the other two, in a cybersecurity sense, is unparalleled. So the idea that somehow you could ditch someone like Microsoft and find something better is la la land. It's just impossible. It's not going to happen. The third point I'm going to make, and that probably explains why some of our clients are not running for the hills, is that it's too early yet. We have zero regulatory guidance as to what companies are expected to do. There's zero market practice at this stage. And actually, if you look at who's leading that market practice, it tends to be the big US cloud companies. So long story short, maybe yes, maybe not, maybe the paperwork is not spot on, maybe there are additional safeguards is not what in the end EDPB, whenever they deem it appropriate to come out and give some guidance, is going to confirm is acceptable. But you can take a view, you can look at the data that you transfer there, you can do the data export impact assessment that Steve spoke about, and then to a certain extent you need to take this with a measure of logic and basically take on some risk. But if there is a particular data that came through your data export impact assessment that you're really concerned about going to the United States, then have a think about whether in relation to that particular data set, you could do something different.
Great, thanks very much, Antonis. We need to keep it real on this show. We love this. It's really, really great advice. Okay, so the next question, as the EU model clauses are only based upon data controller to data processor, to address the Brexit issues, many organisations have set these clauses in place with the DP acting as an agent between the DC and the sub-processor appointed by the DP, with addendums to contracts being signed by the DCs. Do you anticipate the anticipated new standards for the use of the EU model clauses will render this approach unpalatable to the regulators? So does anybody want to pick up on that one? I can't believe I managed to say it all.
Would we be correct to try to paraphrase? And I have total respect for the question, but genuinely I got a little bit lost. But I did pick up the piece about what is the future going to be in terms of how we will manage after Brexit, in relation to data controllers, data processors, perhaps located in the UK. You know, if other people have other things to add after me, but I think it boils down to the relatively simple and terribly complex concept that the UK will be a third country after the 31st of December of this year from the point of view of the EU, and therefore for transfers coming from the remaining 27 countries into the UK, the same requirements as you might talk about today for the US or China or Russia will need to be applied. And look, it's very difficult in a negotiation phase to listen to both sides and what they say, but some of the things that are being said are raising issues in that the European authorities have referred to concerns about use of data in UK intelligence services, and UK authorities have referred to the fact that they may have freedom to make further changes and move away some bit from GDPR. All of that is speculation. I think all we can do is look at what we have at the current situation, and it boils down to exactly what we've been saying for the last 25 minutes or so. We need to do the assessments, need to understand the transfers and manage accordingly. Great. Not sure that I make sense of that, Vicky, but I tried.
Oh, absolutely. No, I think that was perfect. And we do have a show in a couple of weeks' time, actually, focusing on Brexit. So I'm sure we can unpack that a little bit more there as well. So another question, will the judgment change the relationship arrangements for joint controllers and controllers in common across Europe and the US? Any thoughts on that?
I can have a first go.
Okay.
I'm not. I think the answer is no, because from memory, the judgment doesn't touch on that particular point, joint controllership. I may be wrong, but my answer is no. I don't think it will. There's other issues with these relationships, of course, but I don't think the judgment, in and of itself, has a particular impact. No, I'm not sure if any of my panelists have a different view.
No, I would just to, sorry, Antonis. I would just agree with you on that. I don't think it is. So, yeah. Brian, what do you think?
Oh, apologies, Steve. I mean, look, I'm not a lawyer either, but would it be too simplistic to say that regardless, you know, if you're a joint controller, you're still a controller, and therefore you have all the obligations of being a controller, and should view it from that viewpoint first. Other than that, I wouldn't have much else.
Great, thanks, Brian. Okay, so another question. To what extent and how does the case affect EEA processor transfer to non-EEA processors and sub-processors? Antonis, did you want to pick up on that one?
Thanks for putting me on the spot.
Sorry, I could see you nodding.
May I commend your audience, because these are all really interesting and difficult questions. So here's my answer. The judgment doesn't have to do with processor to sub-processor data exports. As we know, this is a major gap in the current, even before Schrems, this Schrems II, this was a major gap in the sort of framework built by the model clauses. We simply don't have exports, SCCs for EU-based processor to non-EU-based sub-processor exports. So despite all that, however, I'm going to say that I think, yes, the judgment does have an impact, because the principle of the judgment is that you export data from the European Union to anywhere else in the world. The organization who is legally responsible for that export is under an obligation to ensure that there are adequate safeguards of protection. And in my humble opinion, the controller, whoever is the controller, wherever they are in that chain, is always going to be responsible for that export. But let's not forget that the GDPR also imposes direct obligations on processors. So, long story short, in my assessment, the Schrems judgment does impose an obligation on organizations, including the controller and the exporting processor, to ensure that any data that goes to a non-EU based sub-processor is protected by adequate safeguards.
I'd just like to say I completely support that, and it goes back to the accountability piece we spoke about earlier. Just because it moves on from the first place that you send it to doesn't absolve you of responsibility. It's still your data.
Thanks, Brian. Thanks, Antonis. I thought that was absolutely spot on and really succinctly put. Great answers to some, as you say, some really tough questions. And I think we probably just got time for one more. There is a longer question, but I think we'll take that offline because I think that's interesting, the due diligence question and the PACs. But we'll pick that up to the person that sent that one in. I think the last question, so this is sort of picking up on the first question, further to the question on Microsoft. What should firms who use US-owned EU processors in the context of the Cloud Act and its lack of requirements to use MLATs? I think there's probably a use. What should they use or consider? Steve, any thoughts on that?
Well, I was hoping you were going to ask Antonis on
Sorry,
this
one.
Because you know, no, it's fine. It's a very technical question on the legal side, and I think this is, you know, what in my mind, the requirements under the Cloud Act go back and I'm just going to talk at a principle level, go back to this same thing that we've been talking about, and Brian just nicely brought it back round again for us, which is about accountability. You know, the big thing about the Cloud Act, and in fact any cloud providers, is that you have to be thinking about where the person that access that data is based, and you know, so what's their location. So that's a really important factor, which I think, you know, going back to the emphasis, what we're trying to get across here is around accountability. But going back to all of the fantastic comments from our guests, what we're talking about is it doesn't devolve responsibility. You still need to be thinking, whatever the framework, whatever mechanism you've got in place to try and safeguard your organisation and the rights of those individuals, you need to be also thinking about the people that access that data, because they may be, if it is certainly cloud, they may be in a part of the world which, and certainly with the pandemic, as you mentioned earlier, Vic, you know, we're all working not in a secure location as we once were. And what access do they have, these individuals that are supporting services and cloud-based services and that sort of thing? But perhaps this last question is either Brian or Antonis. I think Antonis is dying to have a go at this one. I can see he's got that look in his eye.
Let's go with your interpretation, Steve. But look, I was looking at the question. I was trying to figure out exactly where it's going to. And I think if I understand it correctly, where it's trying to get to is if I use an EU-based processor owned by a US company, so let's say I use Microsoft EU affiliate, EU server, everything is stored in the EU. There are no multilateral agreements. Do I still need to worry about the Cloud Act? And again, let me as a typical lawyer put a caveat under what I'm going to say. I'm not qualified to advise under US law, but on the basis of the experience of the work we're doing now and what I'm seeing, US law on law enforcement access takes a very simple, not simplistic, very simple view of things. You're a US company with interests anywhere in the world, and you want data, and you have data that we want, we're going to get it, irrespective of where you store it, irrespective of the corporate structure, irrespective of anything else. So, long story short, if you use an ultimately US-owned company, even if the data is stored in the EU, even if it's that the corporate entity controlling that server is an EU entity, it is still possible to be accessed by US law enforcement under the Cloud Act. I hope that was what the question was driving at, and I hope I answered it.
Thanks, Antonis. Yeah, I do believe that is what it was, but if it wasn't, please do let us know afterwards. And as ever, the time has just gone, and just fantastic panel today, great succinct answers, and just pragmatic advice. You know, we've brought it back round to accountability, we brought it back round to, you know, let's look at the bigger picture, individual rights, you know, ethics. And I love that. I love that we didn't just focus on supplementary measures and how we're going to manage this. We've remembered the bigger picture, and we've remembered, as we are, that it's all about maturity and getting towards driving behaviour towards a privacy culture. And Steve, I think you wanted to pick up on those points there.
Yeah, no, thank you, Vic. I know we've run out of time, and this is always the challenge. And you know, when I was speaking to Antonis and Brian, setting this up, I said you'll be surprised. It goes so quickly because and it's such rich content. And all I wanted to say, Vic, is on that rich content, we are actually creating a white paper. I mean, it's a pragmatic paper, but we've got this paper. It's in draft. We were hoping to have it ready for today, but we thought actually we're going to wait to get the sound bites from Antonis and Brian and then include that in there so we can pour that into the paper. That will be available to our regular listeners and will be distributed wider. And then I just, you know, Brexit, I think this touches on, you know, and there was a big dilemma. I remember you and I talking about this over the summer about, do we tackle Brexit? Do we tackle Schrems? Do we do them both together? but they are separate issues in their own right. So in 2 weeks' time, we have Brexit. Next week, we've got some fantastic DPOs talking about effective privacy program management and the difference between just looking at contractuals, clauses and the contracts, but actually how do you manage this entire program end to end, because completely different skill sets, and that's a challenge. And then on that skill set, we are looking at, in about November, we're looking at, can a DPO be a CISO, or can a CISO be a DPO? Is there a conflict of interest? And this comes into play into all these things that we're talking about today. Anyway, enough of that. Back to you, Vic.
Brilliant, thanks Steve. Thanks for reminding us about what we're doing next week as well, so that'll be great. But I just want to thank finally our guests on the show today. Thank you so much, Antonis. It's been fabulous to have you here, and thank you so much, Brian, as well. So excellent. And to everyone out there, thanks for watching. I hope you've learned something, as ever. I know I have. I know Steve has mentioned he has too, and we'll see you at the same time next week.